You ready? All right, let's roll, nerds.
All right, Judge, page 1, Aguilar, come on up.
You are Jose Aguilar Barrera. You speak English? Ok, toma asiento, por favor. Vamos a esperar.
Judge, I can call the next one.
Ok.
And then I'll text you. Page 11, Jackson, come on up.
You are Latoya Jackson.
This might sound minor, but swapping price tags is straight-up theft in the eyes of the law. Even a $2 sticker switch can escalate into criminal charges. Question for you. Do you think shoplifting laws are too harsh, or just fair enough?
Ms. Jackson, you were charged with fraudulent destruction of a price tag. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to Fleischer. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes,
Okay.
sir.
Good
On
morning.
December 30th, 2024, the officer was dispatched to a theft at a business in Harris County, Texas. Upon arrival, the officer spoke with the loss prevention officer.
Confession alert. Once a defendant admits it, the court doesn't need much more to move forward. That single statement, it locks in probable cause like a padlock on the case.
Officer who advised he was watching surveillance when he noticed the defendant removing price tags off items and placing them on different items in her basket. The total was $136.27, and when the officer spoke with the defendant, she admitted to removing price tags and placing them on different items before checking out.
Jackson, I'm going to find that there's probable cause to go forward with your case. Do you have the ability to hire a lawyer, ma'am? Do you work? What do you do for a living?
In healthcare, work from home.
Okay. What kind of money do you make a month? Do you have any children? Okay. Do you get support for the child? Did you want to apply for an appointed lawyer? Okay. Do you mind giving an application, please? Deputy Lopez is going to give you an application. I'll have you fill it out. I'll see. I need to know everything about you, and I'll take a look to see whether you qualify. If you do, I'll provide you a lawyer today, man. Please.
All right, Judge, I can call us better supervisor.
Okay.
There are any bond conditions for?
Oh, I'm sorry. Thank you so much. Yes. No going, where was it from?
The Walmart?
Okay, no going to any Walmart.
Yes, Judge.
If you don't mind filing that, and then, hey, I forgot to do conditions, and so before she goes, we'll do, no going to Walmart.
That's from the state.
Yeah. All right, you are Aguilar Barrera.
Con palabra.
Sí, soy yo.
Yes.
Okay, sir, you are charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent.
Classic DWI indicators right there. Officers are trained to note these details because they paint a picture for the judge or jury before a single test result even comes into play.
Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer initiated a traffic stop after observing the defendant failed to maintain a single lane and run over a curb in an underpass in Harris County, Texas. Upon contact, the officer observed unsteadiness, slurred speech, bloodshot eyes, and a strong odor of an alcoholic beverage.
And here's the real kicker. When criminal court collides with immigration law, for non-citizens, one arrest can snowball into deportation. Imagine fighting two systems at once, criminal justice and immigration.
The defendant did not consent to standard field sobriety tests. The DIC was read, and the defendant refused a blood and breath sample. A search warrant was signed and executed.
Can you see any prior DWIs? And have you see it?
I have
Texas
no
traffic.
license on file, and there's no prior DWIs.
Okay. Mr. Aguilar Barrera, I don't know what your immigration status is, but if you were in this country without permission and you go to jail long enough and immigration finds you, they will put an immigration detainer on you and you will be stuck in custody until this case is over with. And then you will be shipped off to immigration where you will sit for another 6 to 9 months. You do not have a Texas driver license. You are not allowed to drive. Do you understand?
Sí, señor.
Yes, sir.
I don't care what's going on in your life. I don't care if you need groceries. I don't care if there's a burning building and you have to save 50 kittens. You drive, I can have a contempt hearing. I can hold you in contempt, slap you with another 6 months in jail and or a $500 fine every time you drive. You will be signing an affidavit with me today promising me you're not going to drive. Do you understand?
Sí, lo entiendo.
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're consuming any kind of alcohol or illegal drugs, likewise, you will go to jail. No more PR bonds for you. You got out of jail quick because we gave you a PR bond. If you pick up a new case or violate conditions, I will revoke your bond and you will be stuck in there for at least 6, maybe 10, maybe 12 hours. And that's when immigration will put their clutches all over you. This is the only warning you're going to get. Heed this warning.
Yes, sir.
How old are you, sir? What do you do for a living? How much money do you make a month?
Como unos 3,000 a la mes.
All right, we're going to give you time to go hire a lawyer. So I'm going to have you come up here.
I have an attorney.
Oh, you do?
Sí, hay abogado.
Business.
Androgen.
Oh, Androge? Okay, so this is what we'll do. I'm going to have you swear to us you're not going to drive. I'll get you to Victoria to sign a reset. I'll have you meet with Fleischer for your bond conditions, and then we'll just have you wait in back for your lawyer to arrive.
Gracias.
Please.
Thank you, señor.
All right, Judge, page 19, crawler, come on up.
This guy basically arrested himself. The words "let's do this" are courtroom gold for the prosecution. It shows intent and defiance in one punchy line. Wild, right?
You are Mr. Prowler.
No, yes, sir.
Is it, did I say it right?
No.
Prowler or Prol? Is it Prowler? Sir, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 30th, 2024, the officer was dispatched to a doctor's office in Harris County, Texas, in regard to a criminal trespass. The officer made contact with the complainant and the witness, and the complainant and the witness stated the defendant had an appointment at the doctor's office several hours prior, was asked to leave, and the defendant stated he was not going to leave. The officer found the defendant and the complainant, and the complainant and witness pointed to him, stating that that was the defendant. The officer told the defendant he needed to leave or he would be arrested, to which the defendant refused, stated, "Let's do this," and turned around, putting his hands behind his back.
Have a lawyer, sir.
Yes, sir.
Is he coming here today? Let's do this. I'm going to hold off on it real quick. I'm going to have you take a seat. Let's wait for your lawyer to get here and then we'll.
Exactly what he told me. He told me to just explain to you that.
Don't. Let's wait for your lawyer.
He's asked me to tell me to explain regarding the case itself. He simply told me to tell you he'll be here as soon as possible.
Okay, just hang tight for me, take a seat for me, and then let me know when he gets here and then we'll continue. Okay, any THAs? We're done.
Time to go home.
Let's go home. So I was talking with my other brethren and they said you can on an electric. Hi. So let me see what I can find for you real quick.
I did reach out and I did get an answer back yesterday. And I was told that she can do a portable device, Judge, and that she would not have to do the non-driving affidavit.
Really?
And they sent the contract over, so they would be sending it over to us and let everyone be aware since she does have insurance and since she is eligible to drive.
Oh,
So I don't know where the electric car.
Ms. Gomez said this?
Yes, yes.
Okay, I mean, if that's, okay.
And so I know we spoke with her yesterday, so we got to get, of course, everything notarized, signed, and then get her to get the portable. We're hoping to have everything complete by Thursday because we're set to come back here on Thursday with everything taken care of, Judge.
Here, let me see.
And I don't know the type.
Will you do me a favor?
This is where it gets awkward. Imagine being in a meeting or at dinner, and suddenly your device beeps, time to blow. One missed test, and boom, you're in violation. Which would you choose? Car-only testing or random daily tests?
Give me your cell phone, wait. Right here, just, I'm live streaming, so I don't want you to say it, but if you don't hear, give me your cell phone and I'm gonna text this to you. So in case, because okay, thanks. I'll send this to you now, and I don't know if this is gonna make a difference, but
If you don't know they have to do the type of
okay, I just sent it to you. Just take a look, and I don't know if this is gonna, you know, whether she wants to do this or whether she would rather do the other one, because on an interlock, you're only blowing when you drive versus when you have a portable device, you're gonna blow in it 3-4 times a day. And it may be at, what if you're in a meeting with a bunch of people and then it goes, okay, blow. If you don't blow, you're in violation, then they're gonna kick you out. So let her know that it's probably gonna be at one of the most intrusive times when it's gonna require her to blow versus just getting it in the car. She only blows when she drives.
Yeah, and I don't know why I thought you set a schedule, even with the meeting, you should set a schedule time when you're still required to blow.
I don't know if they put a blow schedule on it in the car. I don't think they do, but I know that when you have a portable, there's always a blow schedule, where here you may not get one. I don't think that they do put blow schedule on it,
Okay, I would
but it's
definitely-
worth letting her know this is an option worth exploring.
Definitely,
So,
okay,
yeah,
thank you, Judge.
for sure. Hey, tell me. Yeah,
We do have another case on docket, Judge.
Okay.
It would be Jesse Barrera.
okay,
This was the one, Judge, that we approached on where we didn't submit the mitigation package because we were awaiting the accident report, which is typically required because an accident was involved in order to get possible entrance into the DWI-PTI program.
okay.
With that said, I know that was the issue of never having the accident report submitted.
You have it now?
I still don't have it, but I did submit the
Sure.
mitigation.
We did request it again yesterday, and we've been following up consistently. There's at
Who
least
are
5
you asking it from?
from,
The actual officer?
yeah, we're asking it from, yes, from the administrator from the constable precinct. We haven't asked the actual officer himself. We've asked the administrator involved.
How many times have you asked?
The prosecutor that was handling it, I know there was a shift, but she stepped out one morning and actually called and spoke to the officer who said she did have an accident report, and it was just a matter of clicking, I think, some buttons to get it on over. And I know that the state has been diligently following up on that, but it's on HPD or whoever.
So let's do this.
constable's
Subpoena
office.
the officer to come to court.
Yes, Judge.
I mean, we'll give it a week. The officer's got to be here in, 7 days with report in hand. Subpoena is taken. If they're not here, I'm gonna have a show cause hearing. The case is 200 days old. We still don't have a damn accident report.
Yes, Judge.
Unacceptable.
And there are some offers, Judge, but of course, we're not willing to move forward on any of
No,
that.
I mean, you got to have all the evidence before you can make an informed decision. And it's 200 days, you still don't have an accident report. You should have gotten that within the next 30 days.
Yes, Judge, we'll subpoena the officer.
So we'll roll to 7/14. I'm sorry,